by the way, among its participants was that notorious criminal organization, Habitat for Humanity. Congress maintains that all other components of executive privilege, besides presidential communications, that the executive branch recognizes, including deliberative process and attorney-client privilege, still quoting here, are not constitutionally grounded and therefore cannot supervene Congress's oversight authority.
Senator Sheldon Whitehouse, a Democrat from Rhode Island, delivers a passionate speech tearing into Emil Bove, a nominee for the Third Circuit Appeals Court. He calls out Bove, a former Trump administration lawyer, for what he sees as a blatant disrespect for the courts, accusing him of arguing that the Department of Justice could sidestep judicial orders. In this 12-minute clip, shared widely on X, Whitehouse doesn't hold back, painting Bove as someone who could undermine the rule of law. It's a fiery moment that captures the high stakes of judicial nominations.
Chairman, let me, as to Emil Bove, let me start with this nominee. Having told a room full of Department of Justice lawyers that if the federal courts didn't back off on restricting unlawful deportations, they would have to tell courts, F you. I hope we can agree that telling courts F you is not an attribute we want in someone seeking to be a judge. We know that he said it because it is so abundantly corroborated in real-time communications among the lawyers present. They talk in texts about the FU comment contemporaneously in that very matter. Prosecutors don't get better corroboration than that. We'd also be on solid ground concluding that he lied about it to us in committee. He said he didn't recall. Really? Didn't recall saying something like that in a Department of Justice meeting surrounded by career lawyers? It's not remotely credible. Lying to our committee also is not a great attribute of a candidate to be a judge. Somehow, he seemed to know that he would get away with it. He also played a bit of verbal dodgem, saying he never instructed anyone to disobey a court order. Correct, but that was not the allegation. He told them to be ready to disobey court orders, to tell courts, F you. Obviously, if you change the statement, you can mislead the committee, but we should demand better than that. Meanwhile, over in the United States District Court of Appeals, there is an order suspending Judge Boasberg's investigation into this matter. He announced a contempt investigation to look into what the hell went on at the Department of Justice with respect to these illegal deportations. Emil Bove is in the thick of that. He absolutely will be part of that contempt investigation. And 2 Trump judges on the D.C. Circuit Court of Appeals suspended that investigation. There's a lot of commentary now about how on earth that temporary hours and days suspension has now lasted, what, a month? Perhaps just in time for this committee to ram through this nominee, likely to be a subject of that criminal contempt hearing, while it's delayed. If we are being played that way, with Trump judges delaying a contempt hearing that necessarily involves our nominee so that he can be shoved through, something is really rotten in Denmark. This whole mess around those deportations and his lying to this committee is all consistent with Bove's lawless character. He helped cook up an improper deal in a criminal case against the mayor of New York, which his own DOJ colleague called a quid pro quo, and an improper offer of immigration enforcement assistance in exchange for a dismissal of his case. That is disgraceful prosecutorial behavior. That colleague, the acting U.S. attorney for the Southern District of New York, then resigned rather than go along with that rotten scheme. And another Trump administration crony also admitted it. Border czar Tom Homan appeared on Fox News with that mayor and said, speaking of the mayor, if he doesn't come through, if he doesn't deliver the immigration support we need, I'll be back in New York City and we won't be sitting on the couch. I'll be in his office up his butt saying, where the hell is the agreement we came to? The agreement. Separately, this nominee tried with acting U.S. Attorney Martin to confect a fake criminal investigation. Tried to confect a fake criminal investigation. Listen to those words. To allow an improper seizure of funds Congress had appropriated and that were obligated and disbursed to the Greenhouse Gas Reduction Fund. Career prosecutors pointed out you can't have a criminal investigation with no crime, with no predication, with no basis. And the career criminal chief who'd worked through multiple administrations was forced out of her job for her pains, pointing out that this was a fake criminal investigation, and they went forward with it anyway, Bove and Martin. These are not minor prosecutorial glitches. These are true violations of the basic oath of a prosecutor. Another principle prosecutors follow is not to publicly disparage subjects of your investigation, both because it's low, it should be beneath a prosecutor, and because longstanding DOJ policy prohibits it. Bove's official client, the EPA administrator, made repeated public statements accusing the fund and its participants and its administrators. By the way, among its participants was that notorious criminal organization, Habitat for Humanity. Accused them of being corrupt, of being criminal, of engaging in kickbacks, of theft, and of graft. None of that is even remotely appropriate. All of it is in violation of DOJ policy, and we couldn't even get answers about that violation. I ask consent that my June 18, 2025 letter to the Department of Justice on these topics be entered into the record.
Without objection.
These are truly evil abuses of DOJ's powers that this person led. Those are some of the problems with this nominee. Then come the problems with our committee process, in which he was pre-licensed to refuse to answer questions. The committee conceded something Congress has never before conceded, that deliberative process and attorney-client privileges overcome our constitutional powers of oversight and advice and consent. Senator Kennedy and I noted this in our bipartisan report on executive privilege in December of 22. I quote, Congress maintains that all other components of executive privilege, besides presidential communications, that the executive branch recognizes, including deliberative process and attorney-client privilege, still quoting here, are not constitutionally grounded and therefore cannot supervene Congress's oversight authority. The majority, having made that astounding reversal and concession, then didn't even follow the rules for assertion of those supposed privileges, neither as to their scope nor as to the process for claiming them. These privileges need to be asserted. It's notable that this nominee never actually asserted them. He likely realized that they don't, in fact, actually pertain, and he didn't want to get caught out in the legal error of asserting a non-pertinent privilege. Plus, he didn't have to, since his non-answers were blessed in advance by the majority. Instead, he hid behind vague claims, not privilege assertions, vague claims of inappropriateness or things not being public or failures to recall. Just to remind, attorney-client privilege and deliberative process privilege, even if they pertained here, do not apply to administrative decisions within a department, and deliberative process, indeed any executive privilege, does not apply where the allegation is misconduct. Again, from my report with Senator Kennedy, quoting the D.C. Circuit Court of Appeals, the privilege disappears altogether when there is any reason to believe government misconduct occurred. We have enormous reason to believe that this individual, now a nominee, participated in government misconduct. The only executive privilege that Congress does recognize requires some proximity to the president. It is not applicable in ordinary agency administration, and the president must invoke it according to the Reagan memo. None of that took place under the blanket authorization to refuse to answer. We are dealing here with a nominee's attempts from a very high position in the Department of Justice to cook up a fake criminal investigation and to use an existing criminal case for political leverage over an elected official with too many accompanying violations of DOJ rules and practices to count. And we can't even get answers? The result was a hearing that more resembled a rackets hearing from The Godfather than a nomination hearing for a Circuit Court of Appeals judgeship. Throw in the Attorney General and Deputy showing up in person to give Republicans in this committee the eyeball, and the resemblance gets worse. Hearing by hearing, month by month, the bar is lowered and lowered and lowered for our constitutional advice and consent oversight. Now to the point where a witness can say, I don't recall, and it would be inappropriate, and that's not public, to any question, no matter how bad the behavior, no matter how good the corroboration, and get away with it. Even with multiple credible, backstopped allegations of prosecutive misconduct by this individual before us, we are become a partisan rubber stamp. Neither the committee nor the judiciary is well served by our learned and servile helplessness.
Whitehouse's sharp words about Bove reflect the deep divide over who gets to shape our courts. His speech, buzzing across X, shows how fiercely people care about protecting the justice system's integrity. It's a reminder of the real human concerns, trust, fairness, and accountability that fuel these heated debates over judicial picks.